Не работает.
Ladies and gentlemen, please take your seat. We will start in 2 minutes. Ladies and gentlemen, please take your seat. We will start in 2 minutes. Шановні учасники конференції, будь ласка, займайте свої місця. Ми розпочнемо за 2 хвилини.
I will introduce. No, not from the beginning, one by one.
One by one. Okay, I will briefly just say. Сказав, я вже сказав. Просто
No, I wasn't here. I came from.
бо якщо ми будемо кожному... So, ladies and gentlemen, we continue, and our next panel is also related to atrocity crimes, deliberate targeting of the critical civilian infrastructure as a means of destruction of civilian populations. And our panelists are Alexei Khomenko, first Deputy Prosecutor General, Diego Cola, Director of Legal Affairs, Directorate Ministry for Europe and Foreign Affairs, Mark Rurda, Senior Advisor on the prosecution of international crimes at EUAM, Fabrizio Guariglia, Director of the Hague Branch Office, IDLO, Philip Koo, Military Expert, Atrocity Crimes Advisory Group, and Zara Kozlieva, Independent Expert. Moderator is Eric Svanidze, International K Expert, Justice Sector Policy and Coordinating Component Lead, EU Project Bravo Justice. So I kindly remind you we have 19 minutes scheduled for this discussion. So
90
please.
or 60?
90.
Wow, great. A good bonus. Yeah.
Let me
okay.
check. 1 second.
That's
No, you're right. 60 minutes. You will not get this bonus. I'm sorry. Please consider this time.
Can we
Thank you.
stick to plan A, which you announced? Okay, good. Доброго дня. Good afternoon, ladies and gentlemen, dear colleagues, friends. And I'm forced to, in the circumstances, to start by mentioning technicalities. And it's not about banal remarks as to the afternoon sessions or after lunch sessions. It doesn't apply to these kind of events, this conference in Ukraine in general, in this context. I flag that this is the shortest session, indeed, unfortunately. Yes, when preparing for the conference, our distinguished panelists have taken it into account. So we will be limiting ourselves to very concise messages, maybe even listing them. As to me, I skip mentioning, as I will downsize the moderator's role in terms of presenting, including speakers and myself. I skip mentioning my experience investigating conflicts, international expertise, and so on, just flagging that I have the honor of moderating this panel due to representing EU Pravo Justice project implemented by Expertise France. That works with the Office of the Prosecutor General and other counterparts, including as one of the Atrocity Crimes Advisory Group partner entities from the EU side. Actually, the majority of international guests here or guest speakers come from different entities under this umbrella. So, but before we proceed with the immediate, very specific issue, which has been mentioned, and this is about mass attacks on energy and civilian infrastructure. I would like to give the floor to sorry, Diego Cola, head of Legal Affairs Directorate of the Ministry of Foreign Affairs of France. And because our project represents France, Expertise France implementer, and I just learned until recently he used to be an ambassador, the ambassador to Georgia of France. So there are several connections. Yes, please.
Thank you very much, Eric. It's a great pleasure to be here, and I really want to thank the Ukrainian government for organizing this conference, because I find this meeting first very inspiring and very encouraging, but also very useful in the sense that there's quite a lot of coordination that we need to, and a lot of thinking we need to do, and we all do that better together. So this morning we had lots of interesting conversations. I was quite inspired, I thought, by the debate on aggression, the debate of this morning. As we know, we have felt as a great honor to be invited to be part of the core group. The French government, we are committed to working constructively and to find solutions and to work the Rubik's Cube so that we can find the solution, the magic solution. And this is what we are very determined to do. I thought the discussion this morning was very intriguing, leaves a lot of food for thought. So were some of the consultations I've had since then. I think we also need to take into consideration not only the question of the personal immunities, but also the question of the functional immunities and what is the exact scope of those, because as we climb the Everest and we're trying to find the route, that might be one way to do so. But I think what has also been striking in these conversations, and now that we are moving on to the issues of more specifically the technique of prosecuting the atrocity crimes, there's quite a lot of specific questions that are being asked to, and there's quite a lot of work to do to make sure that those crimes that are being committed in Ukraine, war crimes, crimes against humanity. I was quite intrigued also by the debate we had just before lunch over the notion of genocide and how it plays. It raises lots of technical, factual questions of how exactly to collect the evidence, to prosecute these cases, and a lot of legal questions as well. Some obstacles need to be found, and it's very, very useful to have these opportunities to exchange that. And I want also to stress, if I can make a little bit of publicity about ourselves, this has been the other issue in which we have been very keen to support and to stand around our Ukrainian friends. One has been to work through the issues of the aggression, prosecuting the crime of aggression, but the other has been all the cooperation done to make sure that those atrocity crimes can also be brought to justice, because this demands a lot of work to do so. So, for example, we in France have deployed quite a lot of tools to help. I remember that when Bucha and Irpin were liberated very early on in the process, immediately it appeared that some absolutely horrendous crimes had taken place there. We have deployed a team of experts, which I think provided lots of support and lots of technique on how to make sure that those crimes can be brought to court. We did the same further in the summer in Izium, bringing these specialists, these DNA laboratory, and we are soon hopefully going to be able to donate another one to further, because unfortunately there are more work to be done. We also have cooperated to the International Criminal Courts Corporation, because they too are having an inquiry, and it's very important to support with financial and technical support to make sure that they can actually deploy and do all these operations. I have been very happy to meet in Paris about months ago a team of the Mr. Prosecutor General who was sent, or prosecutors and police officers who were sent to France for technical training, and we're hopefully going to organize some soon. And also because our own courts are now themselves how to say, they are themselves investigating some facts, either because there's French victims. There could be, so far it's theoretical, but there could be the possibility of French people being deployed themselves being authors of crimes, as if some people were fighting on one side or the other. You could also have a situation where perpetrators are then refugees and are then now in France, but you also have the situation of people who are victims, who are now in France because they are refugees and who have proofs of those crimes in their phones, for example. This is a very specific conflict, and I think we are moving to a new phase in the field of international criminal justice, because there is so much proofs everywhere, and it's especially in phones, and the question of collecting this evidence, preserving this evidence, making sure that it's there, documented and usable, is quite an important question too. And for all this work, it's very useful to have a cooperation, and it's very useful to have moments like that when we can exchange, because it's always on the small things that become big things when they're not solved. But those small things, when we have the opportunity to say, but how do you deal with this? This is what I do. Of course, this is how to do it. This is how we get to successful prosecution. So hopefully we'll get there soon. And in the meantime, I don't want to take more words, but I'm looking very much forward to this panel, because on this particular issue of exactly how to collect evidence, but also how to investigate and how to meet all the legal challenges. It's a bit like this very, very good panel earlier today on sexual crimes, very moving, but also very technical on how exactly we make sure that those proofs are brought to court and do effectively provide justice, which is ultimately what we're all trying to do. So thank you very much, Didi Madloba, for inviting me to this panel and for this great conference that we are all together having.
Merci beaucoup, Mr. Collat. And this presentation reminded me of how this conference has been announced. And it's not a nickname, maybe another second name, Judicial Rammstein. So this is the example of contribution of partners. Yeah, thank you once more for outlining. And we all remember those in Ukraine. And Mr. Homenko, at that time, he was prosecutor of Kyiv Oblast. No, it's not your presentation yet, but I'm talking about the French expert gendarmes coming in April. We all remember. So they were first on the ground, pioneers. So, and it continues. Yeah, thank you. So, and now we are moving towards the narrower issue, immediate topic of our panel, that it's a logical continuation of the discussions, but very focused, of discussions we had earlier this morning. Yes, and it's one more examples or indications, clear indications of what almost every speaker yesterday, today, and tomorrow mentioned or will be mentioning. This is that the atrocities committed against Ukraine, its people, are unprecedented in terms of scale, brutality, consequences, and at the same time it requires accordingly unprecedented legal remedies. So, and the nuances here are very much related to the innovative, maybe, dynamic interpretation of very conservative, rightly so conservative, IHL norms. However, yes, these very specific set of issues we are discussing are the and the relevant patterns, weaponry used, is very much, I would say, to repeat myself, indicating or suggesting that we should look at many issues, or the atrocities, the specifics. Their specifics require us to look at the norms and legal response very specifically. And now I would like to pass the floor to the first Deputy Prosecutor General, Mr. Alexei Homenko. And I would like to ask him to, or suggest to outline the initial results of military analytics carried out by the Prosecutor General's office, its militarily analytical support structure, interagency working group, or as we call it, IWG, and touch upon consequences of mass attacks on energy and related infrastructure. We heard the presentation of the Minister of Energy, and in terms of factual things and further analysis and linkage to the legal dimension of this issue. So this is the presentation that addresses kind of this angle of the attacks. Please, Mr. Homenko, the floor.
Дякую вам, Ерік.
Thank you so much, Mr. Swanidze, for the ability to provide this briefing. Good afternoon, dear participants of the conference. It is a great pleasure for me to speak in front of you and talk about the military and legal assessment of attacks on infrastructure facilities of Ukraine. Many of you might ask the question, why is the prosecutor providing military assessment and military qualification of these strikes? I would like to tell you that I'm here not only as a prosecutor, but also as the co-chair of the Interagency Working Group established at the Office of the Prosecutor General. The Interagency Working Group comprises of a range of active duty service members of the Armed Forces of Ukraine and other elements of the Ukrainian Defense Forces who are subject matter experts in almost all types of weaponry that the Russian Federation is equipped with, starting from cruise missiles all the way to drones. Their work is coordinated by the former chief of the Ukrainian military police, Lieutenant General Christian, and the prosecutors and investigators, while investigating crimes committed by the Russian Federation, utilize the knowledge and skills and the abilities of these experts. It is not a secret for anyone that after the military failures on the front lines of Russian Federation, especially after they were forced to retreat, Kiev, Chernihiv, Sumy, in particular Kharkiv Oblast, it is not a secret for anyone that the enemy has changed their strategy and has concentrating on attacking and targeting specifically civilian infrastructure of Ukraine. As Eric has highlighted, while I was the head of the Kiev Oblast Prosecutor's Office, I want to tell you that at the beginning of war, we have received claims about shellings and attacks, 50% of which were military and 50 were targeting civilian infrastructure. However, starting from a certain point, specifically end of March, almost 90% of all attacks and strikes were targeting civilian infrastructure and civilian facilities. Our experts, the experts of the Interagency Working Group, have developed a presentation that can be a clear visual demonstration of the scale and provide also a military assessment to the strikes that Russian Federation is delivering, targeting civilian infrastructure. On the first slide, you can see the spectrum of munitions, main munitions, that Russian Federation is utilizing to target Ukrainian land, including critical infrastructure. Those are different types of munitions, from the less impactful, starting with the loitering munition Shahed, with the warhead weight of up to 50 kilograms, all the way down to the most deadly, notorious Ha-22, with a warhead weight of up to 960 kilograms. On the next slide, you can see the efficiency of these munitions. The most horrible thing is the least accurate and least precise munition is the most deadly, Ha-22, that was used to target a home in Dnipro, a mall in Kremenchuk, that has caused the gravest casualties amongst the civilian population. As you can see, the deviation from target of this missile is up to 1 kilometer. The remodeled S-300 missiles are also not very precise, and the Russian Federation has an almost endless supply of those. But the enemy is trying to utilize more and more missiles to deliver critical damage. On this slide, you will be able to see the strikes of Russian Federation targeting food infrastructure. As you can see, they have also started from March, and they have only ended after an immense amount of international pressure after signing of the grain deal. Of course, they did not stop completely, but the number of the strikes has decreased drastically in July of last year. That was an attempt of the Russian Federation to force Ukraine into starvation. Next slide, please. On this slide, we can see the time-based distribution that starting from October 10th, we have a specific date when the number of strikes targeting critical infrastructure has grew. We know very well why it started in October, because the temperatures decreased in October, and because it was done to bring upon calculated conditions in order to make sure that Ukrainians suffer. In order to understand the scale of what could have happened to our country if it wasn't for the excellent job of Ukrainian air defense units, especially protecting critical infrastructure, I suggest to all of our guests to take a look at the videos from 2006 about the situation in Alchevsk, when a tiny city was up to 100,000 inhabitants was left without heating due to certain technical issues. The entire country came to the rescue, and the country wasn't at war back then. 60,000 residents were evacuated. So, can you all imagine what would have happened if the situation in Alchevsk would have been repeated in Kharkiv, Dnipro, Kyiv, Zaporizhia, and other large cities? How well we would have been able to cope with those circumstances. I'm doubtful that we would be able to do that. On this slide, you can see very clearly the goal of the Russian Federation. Only 20%, I want to highlight that again, only 20% of strikes are successful because of the efforts of our air defense. So we can extrapolate what the goals are. It is the creation of the conditions that would be absolutely unsufferable, unbearable for the population. And the only reason why Russian Federation was unable to achieve that is because of something that lies outside of their control. It is only because of the heroic acts of Ukrainian service members and also experts that were able to deal with the consequences of the strikes very quickly. This is a slide that demonstrates the dynamics of the strikes targeting certain energy infrastructure. We have talked about Kyiv a lot, and it is important to understand that even a small distribution station in the settlement of Nalivayev has been struck on more than 10 different occasions by the Russian Federation. They've even used hypersonic Kinzhal missiles that they have only a couple of. Moreover, Russian Federation is targeting not only energy distribution infrastructure, but also generation facilities. And hydro generation facilities are the most dangerous because, as you know very well, the strike in Dnipropetrovsk Oblast in the river Ingulets caused the water level to rise by 2 meters. And it has threatened the lives of more than 200,000 residents of Kryvyi Rih. The strike on the Kyiv artificial sea Kyiv water supply has threatened the lives of 500,000 residents of Kyiv. So the enemy knows very well what could have happened and what did not happen only because of the efforts of Ukrainian air defense. This is pride and joy of our specialists. There has to be an animation on the slide. I don't know what has to happen. I think if you click again, there has to be an animation there. Well, too late now. So on this slide, you can see the level of command responsibility of the armed forces of the Russian Federation. With the help of our experts, we are able to identify the perpetrators of the armed forces of the Russian Federation. We're definitely focusing our attention not on the tactical level commanders, but rather on the higher commanders of the branches and services generals. The general who is responsible for delivering most significant strikes, General Kabilash, we have identified him, and he has been served the indictments. He's the commander of the long-range aviation of the Russian Federation, and also the admiral, the former commander of the Black Sea Fleet of the Russian Federation, Admiral Osipov, who was in charge of organizing and planning the shellings of Ukrainian critical infrastructure with cruise missiles from the naval base launch pads. To summarize, oh, look, it's going now. Here you can see a visual representation of the strikes. What I have told you about the General Osipov, where the threats were coming from, targeting critical infrastructure. And I would like to highlight once again that the goal of the Russian Federation was to bring upon conditions that are supposed to be insufferable for the population. And the only reason why that didn't happen was outside of their control. I would like to conclude my report by thanking all of the experts from the armed forces of Ukraine, the members of the interagency working group, who together with our prosecutors and investigators, in mortal danger sometimes, because all of you know that they're going out to those field trips, visiting the locations where the Russian strikes are targeted to. We have, unfortunately, a prosecutor that was killed in action in Kharkiv Oblast. We have a couple who were concussed, so I would like to thank all of you for that. Thank you. Thank you very much.
So, yes, and indeed, very sophisticated. It's analysis, although initial. It gives some food for conclusions. And one of the very specific number mentioned, 20% reached the target. So, and it means that it's not due to the mercy of the aggressor that the people of Ukraine survived this winter. The nation as a group continues to exist. So the intended impact, as you, Mr. Homenko, rightly mentioned, criminal objectives have not materialized or reached by Russians due to the resistance, military response of Ukrainian armed forces that is being equipped by relevant defense systems and also services, municipal and authorities with the equipment, supplies necessary to mitigate the damages. Yes, these are just foods for thought or potential evidence, proofs of entire and much graver intent of the aggressor. Thank you very much. Now we continue with the legal side of this issue. Again, keeping in mind, I will not repeat myself, no need, save time. I pass the floor to Mr. Fabrizio Guardiglia, head of Hague office of IDLO. And I said that I will not present the speakers, apart from mentioning or their official titles. Still, please briefly, in 2 words, introduce yourself. It's necessary.
My name is Fabrizio Guariglia. As I said, head of the IDLO, the Hague office. Before that, for a number of years, I was a war crimes prosecutor in the ICC, where I was director of prosecutions, and in the ICTY, where I was appeals counsel. I'm from Argentina, and now I'm part of the ACA, and I have been trying to provide whatever support I can to my colleagues and friends in OPG, whom I thank for the invitation. It's an honor to be here with you and for the inspiration that you give to me and my colleagues in IDLO with every day of your work, with your commitment for justice and your bravery. So thanks for that as well. I'm going to be very brief. I'm going to take us away from the facts, and I'm going to take us a bit to the abstractions of the law and some of the legal challenges that I see relevant for the purposes of our discussion, delving a bit in the experience of existing international criminal tribunals and courts and what has worked and what has not worked that well. First thing that I want to say, I have 4 thoughts, and I'm going to try to be as succinct as I can, stay within the time. First thought is, we have to bear in mind that this type of cases, shelling cases, conduct of hostilities cases, are not simple cases. They're not easy to prove. There are a number of complex legal and factual technicalities and elements. matters such as the nature of the target, the intent of the persons who carry out the attack, the manner in which the attack has been carried out, the military value or lack thereof of the target. All these are complex issues that a number of times don't find a simple, unique, clear answer. And this complexity can end up really creating serious problems for the effective prosecution of those crimes. That complexity may end up creating insurmountable difficulties for the judges that have to adjudicate that and have to basically be in a position to grasp issues such as the type of ammunition that was made, the nature of the type of the attack that was carried out, the degree of impact, and at times the judges make mistakes as a result. Perhaps the biggest fiasco of the ICTY is the infamous Kotovina case, where basically a prosecution collapsed based on the judge's inability to really deal with the conduct of hostilities crimes effectively, and the attempt to solve it applying a mechanical rule for measuring when an attack was lawful and when it was unlawful. So this is something that prosecutors have to bear in mind. We also have to bear in mind that an armed conflict, almost by its very nature, is a human tragedy, and that there is a degree of devastation and hardship for the civilian population that is deemed to be tolerable and lawful within the parameters of international humanitarian law. So at times what happens is that what shocks our human consciousness is not necessarily automatically prohibited under the law. And this is also something that sometimes as prosecutors we also need to bear in mind. My second point is that the legal framework is complex. And this is something that we should not try to run away from. We need to embrace it. This is the legal framework that we have. It offers multiple possibilities. At times, these possibilities seem to cancel each other out. They seem to be in tension. We need to basically be able to discern as prosecutors that complexity and to present to the judges clear and compelling cases. So we need to basically try to synthesize and make that complexity easy to understand and easy to digest, and to present something that undoubtedly depicts the commission of a crime. In the context of international humanitarian law, a big complicating factor with this type of targets, energy plants, thermal plants, is that they can fall within what is called dual nature purposes or dual purpose targets. That means objects that by its very nature can, on the one hand, support the civilian population, but can also support the military effort of the opposing side. And if that is the case, they are, in principle, lawful military objectives. For instance, if we go back to the 1999 Kosovo campaign conducted by NATO, we will see that in that context, 6 out of 9 energy plants in Serbia were bombed by NATO. Now, when the ICTY Office of the Prosecutor analyzed that conduct, they concluded that was not tested in court, but their conclusion was that actually in and of themselves, those attacks were not impermissible because of the dual nature of the energy plants. So that creates a layer of complexity. However, we need to bear in mind some important and fundamental considerations. First, the fact that an object may have a dual purpose is not a blanket authorization to bomb that object without any further cautions. It's certainly not a blank check to a party to engage in a systematic campaign of bombing. It is certainly not a blank check for a party to the conflict to engage in indiscriminate attacks and to exceed what is strictly required by military necessity. It requires a clear and demonstrable military advantage flowing from that particular attack. And that is something that has to be demonstrable. It cannot be a speculative advantage. It has to be something that is tangible. Demoralizing the civilian population, for instance, is not a valid military advantage. Now, cutting the communication circuit of the opposing party, that could be a military advantage. So that is also a critical consideration that we need to look. And this is an object-specific analysis. And for instance, what may be valid for an electricity plant, where we may consider that there is some military value because the military apparatus is using that electricity plant to power their computers and the control centers, may not be valid for a thermal plant that only serves the purpose of providing heating to the civilian population. That one would not fall within the category of lawful military objectives. So prosecutors have to dissect each particular attack, look at each particular object, and make an assessment as to whether in that case, basically, there was an arguable military value of the objective or not. But even if there is some military value, that doesn't mean that you can use whatever, thank you, Sarah, you can take whatever attack, means of attack you consider. You will need to basically maintain the attack within the realms of proportionality. And the reverberating effects on the civilian population are a key consideration that had to bear in mind. So even if you have a lawful, in theory, you have an arguable lawful military object, if the devastation that will cause and the effects of destruction of that object will cause in the civilian population are of a certain height, you can no longer claim that you are within the boundaries of necessity. And one important point here, perhaps, is how many times can you claim military advantage? The first attack, when you see that you destroy the power plant, you may think, well, you know, I created a problem for the enemy. The second time when you perform the attack and you see that actually the military advantage that you have created doesn't exist, you're still fighting against an army, but the only ones that are suffering are the civilian population, then you can no longer claim that. The third time, the fourth time, the 22nd time, that excuse is no longer valid. When after a fashion, the only thing that you're achieving is clearly causing hardship to the civilian population, there is no valid excuse anymore under international humanitarian law. I think that my third point, and I'm going to wrap up with two things, is I think that if we conclude, as we should, that a number of these attacks are unlawful, either because the object was not military in nature or because the rules of proportionality were violated, then I think that prosecutors should open the spectrum of possible norms that can apply. And then they should look at not only unlawful attack on civilian objects, they should also look at indiscriminate attacks, blanket bombing of entire areas of where civilian population is present without any effort to distinguish between civilian and military objects. They should also look at the crime of trying to spread terror in the civilian population as a result of the attacks. They should look at the possibility of applying the crime of starvation, as Payam said in the previous panel, by providing, preventing the civilian population from using the means that they need to sustain their lives and their well-being. And they should also look at genocide, as has been discussed in this context, where you will have the dual challenge of showing that, on the one hand, these were conditions created to physically destroy the protected group, and on the other hand, the thorny issue of specific intent on genocide that was discussed in the previous panel. My fourth point is that we should complete this analysis by looking at the connections between the crime of aggression and the destruction of civilian infrastructure. And then I see two connections that are relevant. One is that regardless of whether some of these attacks were permitted or not under international humanitarian law, I would contend that the devastation caused by these attacks and the terrible impact on the safety and well-being of the civilian population can and should be seen as an aggravating circumstance in any future prosecution of aggression, either before a national or an international tribunal. I think that in this sense, forcing the civilian population to endure terrible conditions in the winter without running water, without electricity, without heating, I mean, that has to be something that, if you're going to prosecute aggression, can only enhance the gravity and the culpability of the perpetrator. And the second and last point is that we have been reminded recently by Andrew Kaplan of some findings from the UN Human Rights Committee, whereby when a party to the ICCPR engages in aggression, then any killing that results from that aggression becomes automatically a violation of human rights law. It doesn't matter whether the civilian died in the context of a valid military attack. It doesn't matter. The aggression operates as an original sin and turns every subsequent interference with rights as a human rights violation. That doesn't lead to individual criminal responsibility, but can lead to state responsibility under human rights law. And that's one of the discussions that we had yesterday. We need to look at accountability more broadly, not only in the context, in the narrow context of criminal law and international criminal law, but also in the context of human rights law. So that's my last point. I thank you again for your time and for your patience, and I hope that I have stayed within the time limit. Thank you.
Yeah, thank you, Fabrizio. Indeed, I will be very brief in linking the presentations and highlighting or putting emphasis on your rightly raised issues with, of course, multifaceted complexity in mind, and very small comment on the very general but self-evident, maybe once more very much exemplified the complexity of proportionality and challenges. Whatever is self may be evident to somebody. In legal terms, it's not as that straightforward. With this, I would like to proceed further and pass the floor to Marco Rorda, Senior Legal Advisor at EU Advisory Mission. And I believe, and I would like to one more facet of this complexity I know that we were discussing, and could you please kind of focus, among some other things, on the specifics of the attack decision, considerations and issues at stake here. Yes, please, Mark.
Yeah, thank you very much, Eric. And let me start by saying I'm honored to speak at this conference on this very important topic and this very important time. I'd like to say a few words about the practical sides. And in fact, Fabrizio had 4 points and I have 4 points as well. We didn't agree on this, but that's just a coincidence. I'd like to say some words about the practical side of investigation and prosecution of these types of cases of attacks on energy infrastructure. And those 4 aspects, I think any investigator or prosecutor working on these types of cases should be mindful of. And in fact, all 4 of them apply not only to attacks on energy infrastructure, but they apply in general to missile attacks, rocket attacks, drone attacks, and even some artillery attacks. Now, the first is that this part of the law that deals with attacks and also its application to specific cases requires a thorough understanding of the conduct of military operations. Not only because, as Fabrizio has mentioned, the law itself is riddled with all kinds of military concepts, but also because of the tactical size of these missile and drone attacks could be highly relevant in legal terms. And Mr. Kamenko showed the presentation. It also included some information on the precision of weaponry, which is very interesting. But what is the legal relevance of those measures? And I think you need some military expertise to understand this. And I'll keep this point brief because I know Phil will come back to that as well. Now, the second is that the law on the conduct of hostilities regulates, and this comes back to your question, Eric, regulates not the attack outcome, it regulates actually the attack decision. And the legal standard of that attack decision is that of reasonableness. So this means that also the focus of the investigation should be on that attack decision. So take as an example the rule of proportionality mentioned by Fabrizio that balances military advantage on the one hand and civilian harm on the other. What is regulated by the law is not the actual military advantage that was achieved by conducting this particular attack. And it doesn't regulate the actual civilian harm that resulted from an attack. What is relevant in a legal sense is the anticipated military advantage and the expected civilian harm. So those are issues of the decision before the attack. So the subject of the law is not, is what was known to the attacker at the moment of the decision, and whether it was reasonable for the attacker to come to a certain conclusion on, for instance, proportionality. Now, this is often a difficult thing to grasp, and I see specifically many investigators grappling with this aspect, because it basically shifts the focus from the investigation, from the impact side, from the location where you see the effects of the attack, towards another moment in time and also in space, namely that of the headquarters where that decision was actually made. Now, third and related to this last point, because the law regulates the attack decision and not the outcome, and the investigation should be focused on that, well, headquarters procedures, so to say, evidence collection as to that decision will be invariably very challenging. If you speak of other types of war crimes, such as torture or conflict-related sexual violence or looting, or deportation, the investigation typically starts at the crime scene. And one of the most important types of evidence is forensics, but then also statements of victims and other witnesses. But the investigation basically for those types of crimes works from the inside out. You start at the crime scene and you work your way outwards. But for these missile and drone attacks, it's basically the other way around. The evidence is held at the headquarters, and that's where the investigation needs to start. Almost per definition, those types of evidence that you're looking for are therefore also remote in those headquarters and hidden. Main types of evidence could include, for instance, documentation from the attacking forces surrounding the decision and the orders that were delivered down. It could be radio or telephone intercepts in which these decisions were communicated. And it could be statements from suspects and hopefully somewhere down the line from insider witnesses. But all of these types of evidence are not readily available, and their collection requires, well, let's say a different type of operational activity than your, let's say, typical police type investigation. In fact, it could resemble more of an intelligence operation. So arguably what is important is that in the investigative team investigating these types of attacks, there's a close liaison with also the intelligence community or military intelligence community, both domestic and foreign. Not only to work together to obtain that evidence, but also to discuss the issues involved with using that type of intelligence in criminal cases. For instance, on matters of classification, declassification of information, and also admissibility in court. And then fourth and finally, Eric, if I still have some time left, is that these types of cases commonly know fairly high-level perpetrators. I think in general there's a pretty strong desire to hold accountable those persons that are most liable for the criminal conduct, which basically means the top-level military commanders and senior civilian superiors. But as we heard Philip Sands discuss this morning, it's quite difficult to connect to the crime base the military commander. That is a complex matter of law. It's time-consuming, and success is definitely not guaranteed. And in addition, in Ukraine, there's a legal complexity of the question whether or not the criminal code of Ukraine contains something which is similar to the notion of command responsibility in international law. But now in these types of cases, on missile attacks and the type of weaponry that is being used, which is cruise missiles, as we saw, drones, air defense systems used against ground targets, but also sometimes even ballistic missiles. This is the type of weaponry, normally the decision of which to use them is at a very high level. I mean, we're probably talking about Major General, Lieutenant General, or even Colonel General level. So in prosecuting these types of cases, you don't necessarily need that concept of command responsibility. You could perhaps even use your regular individual criminal responsibility modes of liability, such as, you know, your direct perpetratorship or co-perpetration or organizing and aiding and abetting. So I'd like to keep it at that. Thank you very much, Tiago.
Thanks. Mark, the challenges of assembling evidence, yes, in these kind of cases, and yeah, the decision-making aspects of these and command responsibility are there. Having some more insight in this regard, and based on Mr. Homenko's presentation, I would like to mention that our colleagues are succeeding in this. It's of course not. I'm not assessing the collected evidence and so on in this regard, but yes, the same intelligence is involved, and I believe still there are many difficulties in this regard, and thanks for highlighting. And it's our common goal when we work with our partners to assist them in overcoming these challenges. With this, I would like to invite Mr. Philip Koo, military expert from the also ACA team, and to continue from this on this perspective, the types of military expertise, what would be in addition needed, slightly touched upon previous speakers. Then the issue of synergy with prosecution is very crucial, and there are some other elements related to this linkage of analysis and success of prosecution. Yes, please, Philip, the floor is yours. And one comment. Colleagues, sorry, it's the shortest panel, I told you, so please sacrifice a bit of your coffee break for our remaining speakers, and maybe a couple of questions. Yeah, please.
Thank you. It's an honor to be here, and as Deputy Prosecutor General Komenko mentioned, the setting up of the team of military experts, the interagency working group, was recognized very early on as important by the OPG, and it's a credit to them that they recognize this and set up the team. It's such an incredibly complicated, competent and well-staffed team so quickly. My background that's most applicable to this is as the team leader of the military analysis team at the Yugoslavia War Crimes Tribunal, the ICTY. And the team we had there doesn't come close to matching the range of skills and expertise that that the IWG possesses. The importance of having such a team of experts is evident from the presentations of my colleagues. I'll just go into a bit more detail of explaining why and how these teams work with the Office of the Prosecutor. Military operations are exceedingly complex, particularly in this conflict with a massive conventional military opponent facing Ukraine. The command and control of these operations is exceedingly complex. The weapon systems that they use are complex and highly technical. The missile attacks that we're talking about here and artillery attacks, they come from air, sea, and ground forces. The determination of who's responsible for the target selection, who's responsible for ordering the operations, the military advantage in each target that may or may not exist. These are questions that really only individuals with technical expertise in military areas can support and answer questions properly for the prosecutors and investigators. The types of expertise that the interagency working group has include artillery, missile, analytical expertise. And in addition, they have IT and database support and geographic information system support. On the analysis side, the amount of information and the complexity of the information available is massive. They don't have the luxury that we had in the Yugoslavia Tribunal of access to archived documents, the Yugoslavia military archives, for example. The volume of information, the technical complexity of the information is extremely challenging to manage. You cannot possibly do this without the individuals with the technical skills, the understanding of military operations, military weapon systems, and the time needed to collect and analyze, assess the information with the guidance of the prosecutors, providing them with the parameters to work within, to put together a picture of the command and control, the structures, and the operations of the Russian forces. And it's fine to look at some of the online sources, resources, and think that it's easy to figure out what the structure of the Russian forces is. But in wartime, those structures change. The command relationships change. Temporary tactical groups are put together. Resubordination of assets occurs. You have to take this into account. You have to work from the understanding of the peacetime establishment, but figure out what was going on in real time when the attacks were conducted. In addition to the technical and the analytical experts, the prosecutors can be assisted by experts in command who have had previous experience commanding large military formations in operations, and who can comment on, who can offer opinions on the conduct of operations by the Russian forces, whether those were reasonable, whether those the targets selected had military benefit or advantage, and can offer insights into the responsibilities of senior commanders in planning and ordering military operations. So the roles of experts on or outside of the IWG include technical advice to prosecutors and investigators. That technical advice can include advising on questioning of witnesses, particularly prisoners of war, the technical questions to put to those individuals that may assist with building command responsibility cases. The assessment of evidence that has been collected, the credibility of witnesses who claim to know about Russian military operations, where gaps exist, where follow-up questions could be asked. Assessing indictment drafts from the technical perspective of military operations. Assessing defense evidence to help challenge defense evidence. And I can provide a bit of background on how the UNICTY employed similar experts to the IWG and external experts. And in a nutshell, it was the military analysts working for the Office of the Prosecutor put together a picture of the military operations, the command and control, and the structures of the forces of interest that the accused was alleged to have commanded. These military analysts, to a large extent, ended up testifying as expert witnesses in a number of cases at the ICTY, leadership cases. They testified on the basis of reports, rigorously sourced reports that put together a diverse collection of evidence that otherwise would have been almost meaningless to present individually or through other witnesses. They were complemented by usually senior officers, generals who had command experience and could offer opinions on the conduct of command and control. And in addition, they were complemented by technical experts, such as shelling experts, who could conduct crater analysis and explain how artillery was employed. So to wrap up, I think the OPG has to be commended for putting together such a capable team of military experts and recognizing the benefits of it so early on. It's a long process, and it requires very careful collection and assessment of evidence. And I think they're very well situated to be doing that. Thank you.
Thank you, Philip. Thank you for confirming the key team is there in terms of analysts available, but of course the work to be done is immense, unfortunately. So, and without further delay, I would like to invite Zera Kozlieva, since very recently independent expert, but we all know her capacities and indeed expertise, and I'm sure she will outweigh, not compensate, outweigh our male contribution. Go ahead, please, the floor is yours.
Дякую, Ріко, за таке представлення. Всім доброго дня.
Eric, thank you for the introduction. Good day, everyone. It's a great honor for me and a great responsibility to contribute to the conference today, as this is a topic of great professional and of great personal interest, because I grew up in the Crimea, and for 9 years I haven't been able to return home. The reason why I keep coming back to the events of 2014, I'd like to remind everyone that it's the 9th year of war. It didn't start on the 24th of February last year, because the missile strikes we've been discussing today are part of the consistent policy of inhumane way of waging war by the Russian Federation. Yes, it was 9 years since the day when the Crimean Tatar activist Rishad Ahmedov was abducted, a father of 3 minor children who went on a single-man picket against occupation in 2014 for 8 years of the armed conflict since the 24th of February. The aggressor started waging the massive war with massive attacks on the innocent civilians, on the peaceful towns, by attacking the hazardous facilities as the nuclear power stations, and we know the atrocities committed on the occupied territories. Therefore, we can assert that the policy of terror, the policy of intimidation of the civilians, is part and parcel of the Russian policy throughout the 9 years of war, and intimidation and terror of the civilians underpin the entire war, the entire armed conflict that is now unfortunately unraveling in Ukraine. To speak of the missile attacks on the energy generating facilities, on the energy grid, today we've said that they went back to October and actively continued throughout winter, as the Ukrainians were most vulnerable to the consequences of the missile attacks. So it's not just a question that the intent was to deprive us of the key factors that are critical for our survival, but also they intended to cause terror, but also panic amongst the civilians, and the response of the people, and perhaps exercising pressure on the leadership of the country. So this is a very consistent and calculated policy that the Russia is pursuing, and it did not only manifest this year. So when the attacks were launched on the energy grid, they couldn't fail to know, or they could not be oblivious to the consequences. And that has to be considered when qualifying the international crime, the atrocity crime, and proving it in court, which is one of our key objectives today. And another point I would like to say is that the intent to plunge Ukraine and Ukrainians into the black abyss, depriving us of the basic living conditions, is confirmed through the comments of the propaganda pundits of Russia, not only propaganda pundits of the Russia, but also their officials as well. To some degree, to recap this panel and this topic, I'd like to say that we've talked about the qualification of the international crime, that this is the gravest of crimes, the hardest of crimes. And most experts have no doubt that it constitutes the violation of international humanitarian law, the prohibitions of the Geneva Protocols and Protocol 1 to the Geneva Convention about the intimidation of violence or threat of violence to the civilians. So without doubt, it constitutes a grave violation of international humanitarian law, but also considering how far-reaching were the crimes, how systemic was their nature, it also indicates they're part of the crimes against humanity. And international experts, the official seats of the competent authorities that we work with, are firmly stating that these are the crimes against humanity, and we should treat such crimes as crimes against humanity. Moreover, there's been a lengthy discussion about qualification of the offense as the offense of genocide, and considering the context of the armed conflicts, and I wanted to revisit 2014 for a very good reason, and it is the entire armed conflict that has been ongoing for 9 years, considering the statements by the outlets of Crimea, speaking on behalf of the Russian Federation leadership, considering the testimony we've heard today, the testimony of the victims and survivors of the crimes committed by the Russian Federation in Ukraine, and considering the overall structure of the atrocity crimes committed over the years, we have the right to prove the genocidal intent, which is important to proving the crime of genocide. Therefore, I believe, without further ado, I would like to underscore that our key objective is not only to discuss the way we are going to qualify the crimes, but collect the right evidentiary basis that will crystal clearly define the nature of the crimes. And this is a big challenge for the national and the international legal systems alike, and we need to complete the investigations with fair legal verdicts that will yield justice to the victims of the conflict. And these verdicts, both passed nationally and internationally, have to demonstrate that we are winning on the legal front, but we are also winning in this war of values, in the war for justice, for accountability, the right to fair trial. These are values long forgotten in the aggressor country. We have many challenges ahead of us, but with this unity of the Ukrainian nation and unity of the entire world for justice is truly unprecedented in history. So I'm certain that we shall prevail, and I would like to thank all those standing with Ukraine today.
taking us further and suggesting this retrospective and linking to the start of the current conflict. And it wasn't February, it was indeed 2014, and mentioning, suggesting some comments very valuable on the crimes against humanity dimension and so on. So with this, we completed the interventions of our distinguished panelists. Many thanks, dear colleagues. We tried to, but didn't succeed. To stick to the timelines, but we have still time for questions, comments, while maybe you are considering it. As a kind of summing up of this panel, I would like to suggest one more consideration. Yes, the range of damages, consequences, as far as mass missile attacks are concerned, starts from the immediate civilian casualties, each of them matters, and another extreme, down or up to maybe in terms of the numbers or the group affected and concerned is, let us think about psychological suffering of the population living under permanent threat and danger of being attacked. Many of us have visited crime scenes, and we say that we witnessed the evidence of the atrocities. But however, if we consider these dangers, and I don't suggest that we qualify internationals who come to Ukraine for being considered as victims, but just mere fact being on Ukrainian soil, to a degree not comparable to entire population, we feel ourselves what is it to hear sirens, to be under non-stop psychological pressure of not being protected by the civilian status, maybe to the contrary. So this issue of the conditions, life conditions of the is also one of very, and it continues. And the systemic attacks, indiscriminate. So yeah, everybody is kind of under, likelihood is something we all risk. But yes, this is also one more dimension we should assess. And it will unfortunately continue. Any comments, remarks, questions? Then we proceed with a coffee break, I believe,
yep.
And discussions tete-a-tete or in smaller groups. Thank you for your attention.
Thank you very much, distinguished panelists. Yeah, we have 13 minutes for a coffee break, and then we will continue. And before you will go and enjoy your coffee, I want to quick remind you that tomorrow morning, near Taurus, Ibis, Astoria, and Bank hotels, there will be a few buses, and they can bring you here at 8.